Hey, all you cool cats and kittens. This is Major Upward. I'm the Command Judge Advocate here at the Basic School, and this is your period of instruction in military law. In case you didn't get that reference at the beginning, that's to perhaps the greatest legal drama of the 21st century, The Tiger King. We're not going to be discussing that today, but we are going to be discussing military law, military justice, and what you need to know before you go to the fleet. If you have any questions, please write them down. You can contact me afterwards. I'll make sure that my contact information is available so you can ask me any questions. But really what this class should be called is this: How I Learned to Stop Worrying and Trust the Judge. If you learn nothing else from this class, it should be to make friends with your judge advocates. They're sitting probably beside you, either legal Marines of some form, and you should get to be friends with them. Because they will help you in times of need. Even though people don't generally like lawyers, they are there to help, and that's what we're here to do. So let's talk about what we're going to be talking about today, which is the scope of military options for the commander. Not everything goes to court-martial, not everything goes to NJP. There is a wide variety of options available for a commander to deal with military justice issues. And let me just say, you may never do a lot of things that you learn at TBS. You will deal with military justice issues, I promise. So these range anywhere from extra-military instruction that you can see on the left, all the way up to general court-martial that you see on the right. And it is a spectrum, an escalation of force, if you will, as how to deal with military justice issues. We're also going to cover administrative separation and what exactly that entails. So where does military justice come from? There's a difference between the military justice system and the regular justice system. The federal system are standing courts. That's where they come from in the Constitution. We are courts convened as needed. We are not a standing court. While a federal court may have the Ninth Circuit, military courts don't have that kind of permanency. They are convened by convening authorities as needed. I mentioned the Constitution. Like I said, federal courts come from Article 3 of the Constitution. They are the judiciary branch. Military courts are actually created through Article 1, the legislative branch. Congress gives us the permission to do court-martials. The manual for courts-martial is legislative in nature. All of the authorities that are in the manual for courts-martial, while sometimes based in constitutional law, are actually granted to the military through a legislative means. Another difference between the federal and military justice system is if you've watched Law and Order, if you've watched any kind of legal programming, you'll know that the U.S. attorney is the one that makes deals, is the one that determines charges. That is not the case in the military system. The convening authority, the commander, is the one that refers charges to court-martial. Our prosecutors actually have very little prosecutorial discretion. They say whether there's probable cause to charge something, but they're not the ones who negotiate deals. They're not the ones who decide, if you're going to offer immunity to someone and not to someone else. They're involved in that process, but their level of discretion to offer those things is actually very small. Finally, for federal and military courts, the jurisdiction in federal courts depends on the act and location. So, as it says, that's a gross generalization. But usually, if you were in California, you might fall under the jurisdiction of California. Here in Virginia, you would fall under Virginia, either the federal level or the state level. For the military, the jurisdiction for certain acts depends on the act and the person's military status. The military has jurisdiction everywhere. Even now with the newly formed Space Force, the military has jurisdiction everywhere over the person. That doesn't necessarily mean they have jurisdiction over the act per se, but very often the military will have jurisdiction over both of the person and the act, regardless of where it occurs. So the convening authority. The convening authority is usually a commander. The power to establish a trial is usually a battalion or squadron CO or above. The levels of convening authority vary by the level of command. So the CO of TBS is a special court-martial convening authority. He does not have the authority to convene general courts-martial. Same as the CO of CIB here at Camp Barrett is a special court-martial convening authority. As a lieutenant colonel, he has some of the same authorities that the CO of TBS has, but not all of the same in certain cases and instances. But generally, a battalion or squadron or CO or above has the power to establish a court-martial. So I want to move on now to Article 31. Article 31 states that no person subject to the UCMJ may compel any person to incriminate himself or to answer any question, the answer to which may tend to incriminate him. This sounds a lot like the Fifth Amendment. And just in case you aren't clear about that, I'm talking about the Fifth Amendment. That is the basis for Article 31 Alpha. We don't give up all of our constitutional rights when we join the Marine Corps. Some of them are limited, but the Fifth Amendment still is a thing. Unfortunately, because this is online and recorded, my videos don't work. But this is a hilarious video from a police movie where they're talking about Miranda. Sorry, you don't get it online. But Article 31 basically states that a Marine has rights. They have a right not to self-incriminate them. They have a right not to incriminate themselves. So what does that mean? Article 31B writes, every single person in the Marine Corps, if they're subject to the code, has an affirmative duty to read a person their rights when they suspect the person of a crime and they want to question him or her about that offense. Let me give you a scenario. And this is the scenario that usually comes up for Article 31 Bravo. You have a Marine, comes back from a weekend and says, hey ma'am, I was arrested for DUI this weekend. Now, normally we would say, I need to know everything about that right now. But what we should say is, hey Marine, stop. I need to read you your rights. Because you are a person subject to the code and you suspect a service member of committing a crime. And if you want to ask him or her about the incident, you have to read them their rights. This is where some Marines get tripped up. They just don't understand 31 Bravo rights. Or they say, hey ma'am, I don't want to find out about the incident because I'm interested in reading them their rights and getting them in trouble. I want to talk to them for a leadership issue. But the reality is, even if you're talking to a Marine to find out what's wrong with them for a leadership issue, quote unquote, that information can still be used against that person in a court-martial. You have no privilege with your Marines. That information can be used against them. And because you're subject to the code, you have an affirmative duty to read them their rights. Well, ma'am, what happens when somebody just starts talking and I haven't asked any questions? Look, this happens. You may have a Marine that comes to you and says, hey, I got a DUI this weekend. And you read him his rights and start talking to him about the incident. And then he says, and oh, by the way, I also have a pound of cocaine in my trunk. That is a spontaneous admission. You can listen as long as they talk, but don't try to use the loophole. As soon as the Marine tells you of a new crime or tells you of something that you believe is a crime, you must give an Article 31 Bravo rights advisement. And that's before you ask any question. The best practice is to read them the Article 31 rights card or form verbatim. And if you're not sure where to find this, all you have to do is Google Article 31 Bravo. I guarantee it will come up. There's also a version of it in the JAGMAN. And we're going to talk about JAGMAN investigations in a separate class, but there is an entire form that says, hey, these are your rights. And the person initials beside each of their rights that they have, and that they can waive those rights in order to speak to you. So before we move on to search and seizure, I just want to say this about confessions. Do not be afraid to read a Marine their rights. Something that I hear very often from Marines is, I don't want to read a Marine their rights because then they're just going to clam up. That's simply not true. Most times, Marines will tell you the story, even if it's incriminating. Your responsibility is to the code. you have a responsibility, if you believe that Marine has violated the UCMJ in any way, to read them their rights. And if they waive those rights and speak to you, so be it. But just make sure that you're reading them their rights. Okay, so let's move on to search and seizure. A search is a quest for evidence, and a seizure is a taking of that evidence. This is also covered in the U.S. Constitution. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now that is written in legalese, I have no doubt. But here's what you need to know about this. Even in the military, you have a right to not be unreasonably searched or your property seized. Any search must be supported by probable cause. Remember, a search is a quest for evidence. If someone suspects you of a crime and believes there is evidence of a crime somewhere on your person or in a place that you have a reasonable expectation of privacy, they must issue a warrant based on probable cause. And that warrant must particularly describe what they're looking for and what they want to seize. That is what the Constitution requires. So, a search authorization. We often refer to these as a CAS, or a command authorized search authorization. It's like a search warrant. It's the same as if you've watched any legal TV show. It's like a search warrant. Here's what you need to know. Only the CO can authorize this. I'll say that again. Only the CO can authorize a search warrant. This authority cannot be delegated. The question I get almost all the time is, well, ma'am, what if the CO isn't on deck? What if the XO has acting authority? The reality is this. By direction or acting authority, as far as administrative matters are concerned, are completely different from what is required in the legal sense. Acting in the legal sense is only valid when the commanding officer is away and cannot be reached by any reasonable means. What that means is the CO is deployed. He's forward deployed, say in Afghanistan, and he cannot be reached. And there's an executive officer that has been granted acting authority by the CG, acting authority to take command of the RBE. What acting means is that that XO is actually acting as a commanding officer. He's holding formations. He's the one doing promotions. He is the one that's running the unit in the CO's stead. What acting doesn't mean is the CO is not at his daughter's dance recital or at his son's teacher conference and just can't be bothered. That is not acting capacity. So you must make sure that it's the CO who authorizes a search warrant. The other person who cannot sign a search warrant is a duty. I've often heard people saying, well, an officer of the day is acting in the CO's stead. Negative. They cannot sign a search warrant, only the CO. Finally, on a search authorization, it must be supported by probable cause. It cannot be, hey, I just think that Lance Corporal looks funny. I think he's on something. It has to be supported by probable cause. I have observed him with glossy eyes. I have seen him acting funny or acting differently. He smells like marijuana. Those types of things, those observations can lead to probable cause. But just a gut feeling that somebody's into something that they perhaps shouldn't be is not probable cause for the purposes of a search authorization. So what is probable cause? The information must be reliable, relevant, and timely. Military rule of evidence, and I won't quote many of these in my presentation, except for the lawyers who are listening. Military rule evidence 315, it's a reasonable belief that the person, property, or evidence sought is located in the place or on the person to be searched. So you have to have a reasonable expectation or a reasonable belief that you want to search in a certain area for a certain thing, and you reasonably believe that it's where you want to search for it. We often call this the elephant in the thimble rule. If you were looking for an elephant and you said, I must search your house for an elephant. You have probable cause to believe that there is an elephant in the house for whatever reason. Somebody saw it there, somebody hears noises coming from the house that sound like an elephant, somebody saw you walk an elephant into the house, whatever it may be. You have probable cause to go into that house. But beware, if you're going to search there, you must search in places only where an elephant could be. So you cannot lift up a thimble and find a gram of marijuana and say, oh, I have found this marijuana when I was looking for an elephant. And we'll go over that later in searches as well. Probable cause is based on the totality of circumstances. It does not have to be beyond a reasonable doubt. It's just a totality of the circumstances would lead a reasonable person to have a reasonable belief that what you're looking for is in the place you want to search. So who can execute a search? Pretty much anyone. Officers, staff NCOs, law enforcement. But here's the varsity move. I would recommend if you're doing a search, it should probably be done by law enforcement. They are trained in this and they are willing to help. You can have an officer or staff NCO do it in exigent circumstances. However, the best practice to have law enforcement conduct a search. If for some reason you were called on to conduct a search, you must honor the scope of the search. What that means is if they say you're looking for an elephant, you can't be looking under thimbles. You must look in a place where the elephant may be. If a person consents to a search, this is also similar. If a person says, sure, sir, you can search, let me go back. You ask a Marine, hey, I believe there's evidence of a crime in your room. I'd like permission to search your room. Is that okay? And the Marine says, sure, sir, come on in. Except for that black bag over there. You can't go in that black bag. You must honor the scope of that search. If that happens, and a Marine says, sure, sir, you can search my room, but you can't search that black bag over there, you can freeze the scene. You can search the rest of the room, you just can't search that black bag based on his consent. However, if you have probable cause to believe what you're looking for is in that black bag, you can go and ask the CO for a search warrant. But again, has to be based on probable cause. Has to be a reasonable belief that there is what you were looking for in that black bag. And let me be clear, the fact that the person doesn't want you to search in that bag, that alone is not enough for probable cause. Someone exercising their right, their Fourth Amendment right to say, listen, I don't want you to search there, that is not reason enough to give someone probable cause to go into that bag. Same as if somebody says, I am exercising my Fifth Amendment right not to speak, you cannot make the inference that that person is guilty of something. They have a right not to speak. Therefore, you can't infer anything from their right when they invoke that right and not speak to you. So here's the scenario I often give people. You walk into somebody's room and you're doing an inspection, and we'll cover inspections in a minute, and you see this on the table. Is this alone probable cause to search the rest of the room for drugs? I would say this alone is not. Here's why. I am positive there are people watching this class right now who are food preppers. What if they use this to prepare their food? They have so many grams or so many ounces of food, they put it on the scale, they know their macros for that day. Totally reasonable. What if you walked into a room and saw this and there was a white powdery substance on the plate? And there was also dollar bills rolled up at the base of it. Would that be probable cause to search the room? I would say you're getting closer to probable cause now. Chances are this type of scale with the white powder and rolled up bills is an indication of drug use. Now, if you just saw this in the room and you were on an inspection, that is in plain view. You can seize that item if you believe it is evidence of a crime. You cannot seize it just because you think they're a food prepper and they shouldn't be prepping food in their room. So again, just make sure, and if you're not sure, call a judge. So exigent search, here's when there is urgency involved. If probable cause exists, but there's no time to obtain a search authorization, you can seize items. However, it must be urgent. In the scenario I just played out, if you saw that scale in somebody's room with a white powder and dollar bills at the base of it, you saw it in plain view. Perhaps you're in the room on an inspection. Perhaps you're in the room because you just knocked on the door. The varsity move is to freeze the scene, and you probably saw this in a couple slides ago. Freezing the scene is the best practice. You believe there's evidence of a crime. You believe probable cause exists to seize that item. You want to freeze the scene. Get everybody out of the room, post a duty at the door, and then go and tell the executive officer or the CO what you found and ask for a search warrant. Period. That's the varsity move. However, if you're in a scenario where you walk into a room and you see a Marine who clearly has marijuana or cocaine on the table, and the Marine proceeds to run into the bathroom when they see you and attempts to flush it down the toilet, can you see that evidence? Yes. That is an exigent circumstance or exigent search. You anticipate that there is going to be destruction, concealment, or removal of the evidence, and you have probable cause to believe that that is evidence of a crime. You can seize it. My warning is to be careful about this. Again, just because you think somebody looks funny or they maybe, would destroy it, that's not enough reason to have an exigent search. The varsity move, if you can, is to freeze the scene and get a search warrant to seize that item. When is probable cause not required? When it's government property. This trips people up. You are probably currently living in the barracks here at Camp Barrett. Is that government property? And the answer is yes. But you do have a reasonable expectation of privacy in some furniture used for storing personal possessions. For instance, if you're in a room with 2 or 3 roommates right now, you probably have a wall locker that has a lock on it. Even though that wall locker is technically government property, you have a reasonable expectation of privacy to that wall locker because it's yours and it's used for storing your personal possessions. I would argue that you don't have the same reasonable expectation of privacy in perhaps a desk drawer. If you are on the study side of your room and you have a desk drawer that is open and every roommate has access to that desk drawer, sure, it can be used for storing personal possessions. But do you have a reasonable expectation of privacy there? That desk is government property and it's shared by 2 or 3 other people. Just be concerned about whether the reasonable expectation of privacy is used for government furniture that's actually used for storing personal possessions. Here's where we usually see this. When you get to the fleet and you get to a shop, you're probably going to be sharing an office space with other people. There is no reasonable expectation of privacy in that company office. But as I said, a wardrobe in your barracks room, sure, there's a reasonable expectation of privacy that your personal possessions are there, and that requires a search. It is not considered government property. Where else is no probable cause required? Consent. Again, if somebody consents for you to search their items, there is no requirement for a search authorization or a warrant. As I said before, you can just ask a Marine, I would like to look in your wall locker. May I look in your wall locker? Sure, sir, you can look in my wall locker. And they unhook it and they open it and a brick of cocaine falls out. Completely fine. That is a consent search. However, if you have reason to believe that that block of cocaine is there, you should probably tell the Marine that before you ask for their consent. Marine, I believe there's a block of cocaine in your wall locker. I would like to search your wall locker. Do I have your consent to search your wall locker? Consent, 9 times out of 10 is going to happen. The Marine will most likely say yes, and then the brick of cocaine will fall out of the wall locker. That is what consent is. However, if you are going to ask for consent to search somebody's room, search their wall locker, search their bag, and then all of a sudden the person says, you know what, sir, I'm not comfortable with this. I'd like you to stop. You must stop immediately. If they withdraw consent, it is still a consent search and they still have rights. You must withdraw immediately. Again, if they are invoking their rights, that doesn't mean that there is anything there to be found unless you have probable cause based on some other evidence. And if you have that, go and ask for a search warrant. But otherwise, if the consent is withdrawn, you must stop immediately. You also have to honor the limits of consent. I mentioned this before. If somebody says, sir, you can search my entire room, but you cannot go into that black bag, you must honor the limits of that consent. You cannot guess as to why they don't want you to look in that black bag. Maybe they have something in there that's embarrassing. Maybe they have something in it that's personal. I was searched once at the gate, and I told the gate guards that they couldn't search through a bag because I was a defense counsel and I had attorney-client privileged information in that bag. I sat there for 20 minutes before they called the staff judge advocate and realized, no, they couldn't search through that bag. So again, you have to honor the limits of consent. When else is no probable cause required? When something is in plain view. I gave you the scenario earlier, finding the scale. If it's in plain view, you can see it and you have a right to be in the room. You're doing an inspection, you just stop by, you see it in plain view, there is no probable cause required to seize that item or to search and seize that item. However, be careful. Don't be walking into a room and inspection and start opening doors to closets. Like that might be a personal wardrobe. Plain view is plain view. Can you see it without moving something? Another thing that I've seen is people moving covers. What's under this cover? And then they find marijuana residue. That is not in plain view. Plain view as it is when you walk in. You have a right to be there because you're doing an inspection or you're checking on your Marines. You can view whatever's in the room, but you can't purposely move things for the purposes of finding evidence. So I briefly mentioned inspections. Here's what you need to know. Inspections are not a search. Let me say that again. Inspections are not a search. You cannot call an inspection when you want to look for some evidence of a crime. So the scenario usually is, hey, we had some Marines pop on a drug test. Let's call an inspection and search everybody's room for drugs. That is a search for drugs. That is not an inspection. An inspection is to determine the fitness, health, welfare, and preparedness of the unit. The military commander has broad authority to do inspections to do this. Junk on the bunk, room inspections for cleanliness. The military housing units have had problems with mold. So if they're going in to inspect for that, to make sure that where people are living is clean, that is a totally good purpose for an inspection. Like I said, what's not a good purpose for an inspection is when you're on a quest for evidence. If you do an inspection and you're actually looking for evidence, that evidence is not coming in at court-martial because that is called subterfuge. It is an inspection where really you're actually on a search for evidence. Any unit leader may inspect. Some people say, oh, no, it only must be a commander. Any unit leader can inspect. And the varsity move, again, is for your company or your platoon to have an inspection kind of SOP. Perhaps it's once a month, the platoon commander or platoon sergeant will conduct a room inspection. Or once a month, once a quarter, whatever it may be, the platoon sergeant will have a uniform inspection. Whatever the case may be, the best way to do it is to have it in a written SOP. So if there's any other question of whether your inspection is actually a search, you can say, no, look, I have this document that says we do this on a semi-regular or random basis. Here's where most people get tripped up. And for the priors that are listening, I know this is going to sound crazy. Health and comfort inspections. Very often you will hear, guaranteed, of a Marine saying, well, we've had 2 Marines test positive for drugs. We should do a health and comfort inspection. The commander has broad authority to do a health and comfort inspection after people from his unit have tested positive for drugs. But you must be willing to tell that commander, sir, you can do a health and comfort inspection and make sure there is not drugs in your barracks. However, if this is immediately preceding or after 2 people have tested on drugs, it looks a lot like subterfuge. And while you may do that health and comfort inspection, anything you find in that health and comfort inspection cannot be used for NJP or court-martial. Now, it can be used for administrative separation, but it cannot be used for any punishment of any kind. The reason you need to know this is because you need to brief people ahead of you and say, look, you can do this inspection, but you have to understand what you can do with that evidence on the back end. If you believe that somebody is under the influence of drugs or maybe dealing drugs, the better way to do it is to get a warrant. Again, if you have an SOP that states you're going to do health and comfort inspections at a certain point, randomly, once a quarter, and then it just happens to fall, I don't know, 2 weeks after somebody tested positive on a test, you're good. Anything you can find in that health and comfort inspection then is good. The problem is that commanders think of it as an afterthought, and they think about it after an incident has happened, and then they want to go through the entire barracks. They can do that, but they can't use that evidence against those people then, because that's subterfuge. I just love this slide. If you're looking for a peep, if the chick, and you put him in a lineup of peeps, yeah, exactly what that slide says. So let's go over the convening authority options again. This is the spectrum. On the left-hand side, you have extramilitary instruction. That's kind of the low-level way to correct or administratively address issues. General court-martial is like the FPF of options in the military justice. That is basically a felony-level federal court. And then in between, you have all of the other things that we discussed. Non-punitive letter of caution, which is a NIPLOC. Administrative withholding of privileges, such as going to the PX. Non-judicial punishment. Summary court-martial, special court-martial, general court-martial. Something else we're going to talk about is 6105s. Here's what you need to know. All of those things to the left are administrative measures. They are meant to address someone's deficiency. All those things on the right are punitive measures. They are meant to mete out punishment for something that someone has done. So you need to be aware of those differences because they're not all the same. Again, administrative measures to correct deficiency. It can be any small unit who does these administrative measures. Punitive measures should only come for commanders, and it's meant to punish misconduct. We're going to talk about administrative separation as well, but here's the deal. Notice that that's on the left-hand side of the spectrum. Many commanders view administrative separation as a punitive measure. It is not. It is, for lack of a better term, a hiring-firing decision. We believe an incident has happened. We have addressed it either by administrative measures, say a non-punitive letter of caution or a page 11 entry, or we've dealt with it with an NJP. Regardless of how the incident was dealt with, that's how it was dealt with. But an administrative separation is merely, hey, this incident has happened and we just simply cannot have you work for the Marine Corps anymore. So as I said, administrative and non-punitive measures, they are not punishment. EMI. Here's what you need to know about EMI. It has to be logically related to the deficiency. For some reason in the Marine Corps, we believe that filling sandbags translates or is logically related to any deficiency in the military. If somebody's late to work, make them fill sandbags. If somebody mouths off to an NCO, make them fill sandbags. It is not. That is not extra-military instruction. It has to be logically related. Perhaps it's something as, if you have someone who mouths off to an NCO, you have that person serve as a guard for the NCO hut or sit with an NCO on duty for 2 hours a day. But it can only be 2 hours a day maximum, and it is not on the Sabbath. And it's not meant as punishment. It's meant to address their performance deficiency. So keep that in mind when somebody says, well, they have EMI, so we're just going to have them go fill sandbags. That is not logically related. And if you have a question, make sure you ask a judge. Non-punitive letter of caution. Again, you probably have heard this term at your time at the basic school. Here's what a NIPLOC is. It is usually a letter, and it is a written criticism of conduct or performance deficiency. It will usually spell out, here's what the incident was, or here's what your deficiency was, here's how you're correct it, and here is the things that you should do to correct it. NIPLOCs are not punitive in nature. They do not go in your official military personnel file. They cannot be used for the purposes of pros and cons or for fit reps. Although if you're writing a NIPLOC for a junior enlisted member, you should probably just do that in a page 11 anyway. But it cannot go on your record in any way or be reflected in your record anyway. It is merely meant to be a formal letter to you saying, look, this is your deficiency and this is how you need to fix it, but is not meant to need to follow you after that command or on your permanent record. Administrative withholding of privileges. A CO can do this. You cannot restrict normal liberty. In CONUS especially, you cannot restrict normal liberty as a punishment or withholding of privileges. That is not an option. However, you can say, look, you have a problem with stealing. Perhaps it's low-level stealing or larceny. You will not be allowed to go to the exchange. You have a problem with mouthing off to NCOs while you're on liberty. You will not be able to go to the movie theater because that's where that behavior seems to happen. Again, a commander can administratively withhold those privileges, but commander cannot restrict normal liberty, especially in CONUS. So, page 11s and 6105s. Here's what you need to know. A page 11 is different from a 6105. A page 11 is called a page 11 because it used to sit on page 11 of the SRB or the OQR. That is where the administrative remarks were located. A page 11 is simply that, an administrative remark. It can be adverse, but it doesn't have to be. Page 11s that you may have received or may receive is when you receive an issue of steel-toed boots. You receive boots, they want to put in your record that you received those boots, you will sign an administrative page 11. Another administrative page 11 may be, I have been notified of the social media policy or the tattoo policy in the Marine Corps. That would require a page 11 entry to show that you understand those policies. Those types of remarks that have to be permanently placed in someone's record happen on page 11. It can be used to document counseling or to enter basic admin info, and that's the reference that you need to know for a page 11. It's the IRAM. That's where page 11s happen. But don't get confused between a page 11 and a 6105. A 6105 is a formal counseling. It's a formal counseling that has to have specific language identifying your deficiency, sort of like a NIPLOC, and then how to correct them. The difference is with a 6105, it goes on your permanent record. And just so you know, for officers, this is called a 3005 entry. So the reference is the MARCOR SEPSMAN, and that's the order. This order actually changed in February of 2019. Before, the language was very broad about who could give a 6105. As of February 2019, the Marine Corps has limited 6105 entries to special court-martial convening authorities. So, if you have a company commander who conducts an NJP, that's fine. That is within their authority. However, the 6105 that comes on the back end of an NJP must be signed by a special court-martial convening authority. And a company commander is not a special court-martial convening authority. Here at TBS, the only special court-martial convening authorities are the CIBCO and the TBSCO. Those are the only ones. Why would you do a 6105 other than a page 11? Here's why. 6105 has a legal basis to it. If you have a junior Marine who is late to work repeatedly and you want to put a formal counseling on his record that says, look, you have been counseled about this is your deficiency, here's what you must do to correct it, or if you don't fix this deficiency, you may be administratively separated. That 6105 then has a legal premise to it. If it is then coupled with another 6105 for other misconduct, say underage drinking, or a DUI, or a low-level assault, or something along that nature, or another NJP. When a Marine has two 6105 entries that have been properly signed by a special court-martial convening authority, you can then administratively separate that Marine. That's what gives the 6105 its legal oomph, if you will, to legally separate that Marine. Now, if you have a page 11, and a page 11 can be adverse, but it is missing the 6105 language that says failure to do this will result in administrative processing. Or if you have what you thought was a 6105 entry with the correct language, but it's not signed by a special court-martial convening authority, that's a page 11. And if you have an adverse page 11, and then you have a 6105, guaranteed somebody will say, well, look, can't we administratively separate this Marine? He has two 6105s and he does not. A page 11 is different from a 6105. A page 11 is just administrative remarks, and it can be an adverse counseling, but it doesn't have the same legal effect as a 6105. 6105s have to have the specific language, and it has to be signed by a special court-martial convening authority. So NJP. Here's what you use NJP for. Minor offenses. It's usually conducted by the commanding officer, and the authority comes with command, not rank. Here's where people get mixed up. Authority comes with command, not rank, because if you are a company commander or a platoon commander or an RBE OIC, or you are a cognizant commander of some sort of military entity, you do have the authority to non-judicially punish Marines. However, the level at which you can NJP Marines depends on your rank. So when it says authority comes with command, yes, your authority to non-judicially punish a Marine in your command comes with your command, whether that's platoon command or OIC or company command. But how much punishment you can give is based on your rank. Lieutenants and captains can give the same non-judicial punishment, regardless of what their position is, unless it is that has been withheld by a higher commander. So if a company commander says, my platoon commanders can NJP based on their authority as platoon commanders, however, they will not give restriction. That is totally within the commander's limits. They can say you're not allowed to give restriction. That way, if you believe a Marine deserves restriction for the misconduct, you have to send that NJP to the company commander to conduct the NJP. Here's where the issue usually comes. Here at TBS is a great example. Our company commanders are majors. They have the same NJP authority or same NJP punishment authority as the CO of TBS. All field grade, majors, lieutenant colonels, and colonels all have the same NJP authority. They can take someone down a rank, they can take half pay for 2 months, they can give up to 60 days restriction and 45 days extra duties with 45 days restriction. If a major is a company commander, you may hear somebody in the fleet say, well, he only has company grade, company level NJP authority. He can only give 14 and 14 and the same thing a captain would give. And that is not correct. Unless a higher commander has withheld that major who is serving as a company commander has the same authority as a battalion commander or a squadron commander as far as what punishment they can give. But the authority to actually conduct the NJP comes from their command. A Marine has a right to refuse NJP and they have a right to appeal. So they have a right to refuse unless we are on a ship. This is very rare. But if you are deployed on a ship, they cannot refuse non-judicial punishment. They have to go. Otherwise, the Marine can say, I demand trial by court-martial. They also have a right to appeal the NJP, and that's covered in the NJP package. I think you're going to get a separate, if you haven't already, a separate NJP class. Okay, so Judge Dredd. Judge Dredd is what I like to call summary court-martial. It is the lowest level of court-martial, but it literally is judge, jury, and executioner is all one person. It's usually a higher company grade or field grade officer who does the court-martial. It is the lowest level of court-martial that we have. And remember, back to the spectrum, it's administrative in nature. It is not actually a judicial proceeding. What that means is you don't get a conviction, a misdemeanor or felony conviction out of a summary courts-martial, even though that's what it's called. Summary court-martial cannot be the CO. If a CO is taking someone to summary court-martial, he's like, I want to do it. No, sir, you have NJP authority. You cannot be the summary court-martial officer. The best bet is to find an independent officer who does not know the Marine or does not know the misconduct and have them run the summary court-martial. Again, a Marine has a right to refuse summary court-martial. It's an administrative measure, just like an NJP. They can refuse it and say, you know what, no, I demand trial by court-martial. And when they demand trial by court-martial, they either mean special or general. Even on a ship, they have the right to refuse a summary court-martial, and that's what makes it different than NJP. Maximum punishment in a summary court-martial is up to 30 days in the brig. This makes it different from an NJP. You cannot get brig time at an NJP. You can only get restriction. For a summary court-martial, you can get up to 30 days in the brig for a corporal and below. Special courts-martial. As I said before, the authority for special court-martial usually lies with a squadron or battalion CO and above, lieutenant colonel or above. It is not any lieutenant colonel. It has to be a commanding officer, a Title 10 board-selected commanding officer that has special court-martial authority, unless it has otherwise been granted by the Commandant of the Marine Corps. It is sort of we call it a misdemeanor court. It usually doesn't try our heavier cases, sexual assaults, aggravated assaults, murder, all of those things are handled at general. Special is more of a misdemeanor level court. It is a real court. Would be held at one of the courtrooms that we have in the Marine Corps. Here at Quantico, the courtroom is over on Main Side. There will be a judge who is a military officer. There will be a jury, or what we call a panel of members. And there will be lawyers for both sides litigating the case. Both officer and enlisted can go to special court-martial, but an officer cannot get a discharge, meaning they cannot be kicked out of the Marine Corps at special court-martial. Now, if an officer goes to special court-martial and is convicted at special court-martial, they can be administratively separated on the back end. Remember, as I said, administrative separation is a hiring-firing decision. It's the Marine Corps saying, look, you got it, you were either convicted at special court-martial of this, however, we just don't think you should be a Marine anymore, thank you for coming. At special court-martial, the maximum punishment is 12 months. So regardless of what crime a person goes to special court-martial for instance, if somebody goes to special court-martial for false official statement, the max punishment for false official statement under the UCMJ is 5 years. However, if they go to special court-martial, the max punishment is 12 months, regardless of what the UCMJ says as far as max punishment. At special court-martial, a Marine can also receive forfeiture of 2/3 pay for a month for 12 months. So for 12 months, they can receive they can forfeit 2/3 of their pay. A Marine can be reduced all the way to E1. That is, any enlisted rank can be reduced all the way down to E1. And you can receive a bad conduct discharge. We're going to talk about administrative separation discharges in a minute. But special court-martial, you cannot receive a dishonorable discharge or an other than honorable discharge at a special court-martial. You can receive a bad conduct discharge. Now, some people say, well, ma'am, that makes no sense. If they can receive an other than honorable discharge at an administrative separation, why can't they receive it at a special court-martial? That's not the way the practice works. If someone is taken to special court-martial and the judge or the members decide that that person should no longer be a Marine and should leave the Marine Corps, their only option is for a bad conduct discharge at special court-martial. If the unit wants an other than honorable discharge, they will have to administratively separate that Marine on the back end of the court-martial. It is not part of the court-martial proceedings. Okay, so general court-martial, the big kahuna. Only the commanding general convenes these. So the first general in the chain all the way up, generals convene general court-martials. There are some exceptions. The commander-in-chief actually has the authority to convene general courts-martial. That's what was being discussed when the SEAL case for Chief Gallagher was going on over in San Diego, whether the commander-in-chief was going to take general court-martial authority. But usually commanding generals convene these. We call it a felony equivalent court. That's not actually the case, but for ease, because everybody watches, Law and Order, this is a felony level serious court. The difference between general court-martial and special court-martial is a general court-martial requires what's called an Article 32 preliminary hearing. Again, if you watch any law program, you'll see people go to what's called a grand jury hearing. And it's basically where the government presents their case and members decide whether there is probable cause to go forward on that case. Same concept with an Article 32 preliminary hearing. The government presents its case to a preliminary hearing officer, which is usually an independent judge advocate. It's not the unit's SGA, it's not, anybody on the prosecution or defense team. It's a judge, usually a reservist, that is independent of the case. That lawyer will look at the case. The government and the defense will be able to provide documents, some evidence. Sometimes there's witnesses at these hearings to determine whether the Marine Corps has jurisdiction, and then to recommend what forum, if they believe there's probable cause for the charges, what forum that those charges should be referred to, what kind of court-martial. At general court-martial, an officer can receive a dismissal. An enlisted person can also receive a dishonorable or a bad conduct discharge. So as I said, at special court-martial, you can only get BCD. At general court-martial, you can get all the way up to a dishonorable discharge, which is the lowest characterization of service leaving the Marine Corps. Max punishments here are based off the UCMJ. If you look in the manual for courts-martial, there's actually a tab that says max punishments. Those max punishments apply at general court-martial because you can get life without parole, you can get death, you can get total forfeitures. And yes, we do have people on death row in the military right now. Whoops, I went one slide too far. Okay, so punitive discharges. As I said, punitive discharges are punishment for misconduct. Bad conduct discharge and dishonorable discharge are authorized only at a court-martial sentence. So even if you have, for instance, a Marine who is convicted out in town of perhaps a horrible crime. When I was at 29 Palms, we saw a Marine who was convicted in a civilian court for murder. He cannot get a dishonorable or bad conduct discharge unless he goes to a court-martial and is sentenced that at court-martial. That Marine actually ended up getting out of the Marine Corps with an other than honorable. Bad conduct discharge, like I said, only special court-martial or GCM. Dishonorable is a GCM. Officers can only be dismissed at GCM, as I've already covered. So administrative discharges. If you're administratively separating a Marine, whether it's at the end of their EAS or they're being administratively separated involuntarily, you have to characterize that Marine's service. As I've said several times, it's a firing decision. It's saying, look, you're just not going to be part of the Marine Corps anymore. The MARCORPS man has these definitions in it, and I highly recommend if you're ever on an ADCEP board or if you're involved in administrative separation of Marines, you look up these definitions. The MARCORPS man specifically says that most Marines serve honorably. And honorably does not mean that the guy's a water walker or the girl has never had any issues at all. It just means that the quality of their service has generally met the standards of acceptable conduct and performance. What does that mean? It can mean that it's, a 3-0 Marine. They come to work, they do their job, they go home. They don't have to be the honor grad at Corporal's course. They don't have to be your top performer. If they're just doing their job, chances are that their service is honorable per this definition. After honorable is a general under honorable conditions. If you're administratively separating a Marine and you hear that they're going to get GenSept or a general characterization, the definition of this is that the negatives of that person's career outweighs the positives. So again, if you have a Marine that is, has done their 4 years or is close to their 4 years or has only done 2 years, is the negative aspects of what you're administratively separating that Marine for, whether it is a pattern of misconduct or drug use, does that outweigh the positives in their career? And again, a general is not an automatic. Every Marine is different, every career is different. You must look at the definitions to see whether this applies. Finally is an other than honorable. This is the lowest characterization of service you can give at administrative discharge. Again, the definition is a significant departure from the conduct expected of a Marine. So if a Marine has drug abuse or an aggravated assault, I believe the Marquardt man also talks about death or a commission of a serious offense out in town. That is the type of behavior that a Marine should receive an other than honorable discharge. So what kind of separations are there? Voluntary sep, somebody just EASs and doesn't re-enlist, they can separate. Most of those Marines, if they complete their 4 years, will receive an honorable. You can give a Marine a general characterization of service upon EAS. However, you must have the documentation to back that up. They're repeatedly late, they weren't good at their job, whatever the case may be, but it must be a pretty substantive reason why that person was an NJP'd or 6105 for that behavior as well. Sometimes there's early retirement. Actually, right now, I just saw an email just recently about how the Marine Corps is talking about offering early retirement again. Dependency or hardship may be a reason for somebody to be voluntarily separated from the Marine Corps. Pregnancy. Conscientious objector. We don't see this as much anymore, but this was a thing very often during the height of the Iraq and Afghan conflicts. Here is a reason, and this photo makes me laugh because I know this captain, but here is a reason that we very often separate Marines: involuntary separation. That soldier would probably be separated for one of the reasons on this list. So convenience of the government. For some reason, we saw this when the Marine Corps slimmed down. So we went from 202,000 at the height of Iraq and Afghanistan to about 186,000. And the Marine Corps said, look, for the convenience of government, your job is being removed. We just don't need you anymore. We're involuntarily separating you from the Marine Corps. Completely within the government's rights, although it is rather rare. Performance. If a Marine is not good at their job, they can't maintain the standards for their MOS. They can be involuntarily separated or adcept for performance. Drugs and alcohol and misconduct are perhaps the most common ones that we see. Obviously, drug use is, as you hear, I'm sure, is zero tolerance. That does not necessarily mean the Marine will be automatically separated. It means that they will be processed for separation. And Marines get very upset. Well, no, if they do drugs, if they're positive on the drug test, they should just be gone. That is not the letter of the law. They will be processed for administrative separation. Same with misconduct. Pattern of misconduct, commission of a serious offense. Those are all reasons to involuntarily separate a Marine. Weight control, as that photo on the slide preceding, is another reason. But here's what I'll tell you about weight control. If you have somebody who fails BCP or is a PFT failure, the way that those Marines are usually administratively separated are under the performance caveat, not under BCP or PFT failures. The reason being is, if you get to your unit and you're a training officer, that paperwork is very rarely done correctly and thoroughly enough to remove a Marine based on that. You still can remove a Marine for failing multiple PFTs or failing out of BCP under performance. But that paperwork has to show the pattern. The Marine failed a weigh-in, they were taped, they were placed on BCP, they were given, numerous times to remediate and numerous times to correct their deficiencies and just didn't do it. That's what's necessary to remove someone from the Marine Corps for those things. So how does involuntary separation procedures work? There are two types. Basically, there's an ADCEP board, which is a 3-member board. There's a distinct possibility when you arrive at your unit, whether it's at a second lieutenant or first lieutenant, you'll be new to the unit and they'll be like, hey, you're going to go sit on this ADCEP board. It's usually a field grade officer, a company grade officer, and a staff NCO. And you'll sit and listen to the evidence that the recorder or the government's representative provides, saying this is why the commanding officer has notified this person that they want to separate them from the Marine Corps with an other than honorable. And the defense. Anybody that goes to an ADCEP board rates a military defense council, and they will obviously make a case for why that Marine should remain. So at the board, the ADCEP board hears all the evidence, and then they recommend to the CG whether they think separation is warranted. So what you need to know about this is, at an ADCEP board, if you're sitting on an ADCEP board, you listen to all the evidence, and you say, look, we think there's a basis to separate. We think this Marine probably should be separated, but we are only recommending that the Marine receive a general, not an other than honorable characterization. that recommendation is binding on the CG only to the point that he cannot go lower. So if the CG then receives your recommendation and says, got it, the board says that they recommend that this person be separated and they only receive a general, that general cannot turn around and say, no, I disagree, he should get an other than honorable, the lowest characterization. The general, however, can go up if a board recommends, say, an other than honorable characterization of service. Yes, this Marine should be removed and they should receive an other than honorable characterization of service. Then the commanding general can say, look, I disagree, I believe the Marine should be retained. Or I agree that the Marine should be separated, but the Marine should only be separated with a general or an honorable. That is how the recommendation of the board binds the commanding general. Sorry, another video that you missed out on. The other type of involuntary SEP is what's called no board or notification procedure. If you have a Marine that has less than 6 years of service, so it's usually our junior Marines, they do not rate a board. However, because they don't rate a board, the worst characterization of service they receive is a general. So how does this usually play out? A Marine gets in trouble, let's say for drugs, pops on a drug test. Commanding officer wants to separate the Marine. There are two options for the commanding officer. If he believes that that drug use rates an other than honorable characterization of service, then the commanding officer can say, look, notify him that we're taking him to a board. However, if the commanding officer says, I don't think a board is worth it, I just want the Marine gone, he just should be fired, if you will, then he can separate that Marine. The Marine will be notified in paperwork that the commanding officer is recommending to the general that you be separated from the Marine Corps with a general characterization of service. Now, the Marine can appeal that on the back end. They can send something to the general saying, look, this is why I don't think I should be removed. But they do not rate a board if they have less than 6 years of service and the commanding officer is only seeking a general characterization of service. In the end of the day, for enlisted separations, the first CG in the chain makes the decision whether a Marine is going to be separated or not and what their characterization is going to be. The commanding officer, usually your 05s and 06s, are not the deciding factor. They are not the separation authority. They are not the final say on who gets separated or not. They merely make a recommendation to the general. Okay, so just a reminder again of the spectrum of options that are available to the convening authority. We've gone through all of them, including administrative separation and the difference between administrative measures and punitive measures. At the end of the day, when in doubt, consult your local judge advocate. Like I said, make friends with your judges, call them, even if it's not someone that works with you or is in the same unit as you. People in your TBS class are going to be invaluable, just to call them and run these things past them. And no, we don't wear alphas in court. But the reason you do that is here at the basic school, there is a major who is the command judge advocate for a colonel. That is not the case in the fleet. If you work for a lieutenant colonel or a colonel, the first judge or judge advocate in your chain is probably at division or the wing level. They're really not going to have enough time to reach down and just answer your questions. That's why you want to make friends with your judges and ask those questions. So that's the end of my brief. If there's any questions, you can always contact me on email. I'm the only Upward in the gal, but my email address is susan.upward@usmc.mil, and Upward is spelled just like the direction, UPWARD. Or my phone number here in my office is 703-784-5662. Happy to answer any questions you have about the presentation or any MilJust questions that you have at all. Hope you enjoyed the POI, and I will talk to you guys again when we do JAG.